Great, thank you, Stephanie. So I'm Melissa Wright. I'm here in the litigation group at Kaiser Mason Ball, and I'm here with Jennifer Lee, who is an associate here in the group as well, who articled and summered and has now returned back with us. And so we're going to talk a little bit today about navigating contract disputes. And we've purposely kept this topic a bit general just so that we can provide some guidance, because really there are a lot of situations where contract disputes come into play, and it can be in your personal life, it can be in a corporate setting, and we just want everyone to be aware of the different types of situations that can arise and steps you can take to protect yourselves upfront to avoid those contract disputes, and what to do when you actually end up in a contract dispute. So you have some familiarity with the process before you find yourself in that kind of conflict. So Jen is going to start.
Yes.
Next slide, please, Stephanie.
Thank you. So I'm going to start talking about really a precursor to a contract, and this is the letter of intent. Now, letters of intent are often used when a party is interested in selling their business. It really outlines the broad terms of a final agreement and general plan. But a letter of intent really is something that the parties can walk away from. It's not legally binding most of the time, but I'll get to that a little bit later. The real purpose is to clear away any misunderstandings the parties may have, and it signifies that both parties are serious to this deal. It signifies a commitment by both parties. They're entered into in good faith. It helps to establish trust and is really the springboard for negotiations. So like I said, in most cases, it is not a legally binding document. However, there are some instances when it can become legally binding. So when I say legally binding, I mean the court will infer that it is a legally binding contract and that both parties have to execute their obligations under the LOI or what you have listed in the LOI. So to make sure that this doesn't happen, there are a couple things that you can do to protect yourself when you're drafting a letter of intent. So you can include express statements such as this LOI is non-binding. Parties' obligations will only crystallize by a future agreement, or you can say this is not a contract. You can also include a deadline from when the LOI will expire. You want to avoid using terms like it is agreed or this agreement. You can instead say it is intended. You want to be very clear in what you're saying. You don't want to sign a letter of intent. The court has inferred that a signature is an acceptance of a contract. So you want to make sure that there's no signatures on the letter of intent. Again, so actions are very important because a court has actually inferred that letters of intent are binding contracts based on the actions of the parties. So there recently was an Ontario Court of Appeal case within the last couple of years where a gentleman wanted to sell his business, and the buyer and the seller of the business, they entered into this letter of intent. Now the seller introduced the buyer as the new owner. He would make statements as, upon my retirement, the buyer is going to be the new owner. And he said to his employees, the buyer is going to be your new boss. So these actions, coupled with what was put in the letter of intent, the court found it to be a binding agreement. And that's not what you want. You want this really to be a general document to outline your understandings, to be the basis for negotiation, and really you still have the opportunity to walk away from the deal. You don't want it to be a legally binding contract. Next slide, please. Great. Now we're going to talk about the essential elements of a contract, or what is needed to make it legally binding. Now, all contracts need offer, acceptance, and consideration. These essential elements make it a valid contract. I also included parties, however. It's who is bound by the contract. You want to ensure you have the correct parties. Now, I say this because if you're entering into a contract with a company, whether it be a corporation, sole proprietor, limited liability partnership, you want to make sure you're using the correct legal name. And I like to use the example of Home Depot because everyone knows Home Depot. So if you're entering into a contract with them, you actually need to put Home Depot Incorporated because they were incorporated in 1978. So it's always important that you have the correct party names. Now, an offer, this is more of a conditional proposal, and once it's accepted, it becomes legally binding. It really is a promise that one party makes to another in exchange for the other party's performance. Now, consideration, all contracts have this. Both parties give some sort of consideration. It's something of value offered in exchange for something else. So what you're offering, the other party can't already be legally entitled to. So if you're thinking of an employment contract, if you want your current employee to sign a new employment contract, you have to give them some sort of consideration. And this oftentimes can be in the form of a signing bonus, $100, $500. That signing bonus, that amount of money, the employee isn't currently legally entitled to. So that's your consideration. And then you have acceptance. Acceptance of the offer is really what makes the contract legally binding. It must be in writing or through an action. However, we do always prefer that contracts be signed. But if you do start to act out elements or obligations of the contract, it can be inferred as being accepted. But if the party is silent on the contract, then there is no acceptance and the contract is not legally binding. So next slide, please. Great, thank you. So when you're drafting your own contracts, there are some tips or other ways to protect yourself. You want to put it in writing. So if you're having a conversation with someone on the phone or in person, and you come to certain terms that are agreed upon, you want to put that down into writing. You want to condense it into writing in whatever way, because otherwise, if a party fails on an obligation or they fail to do what they're supposed to under the contract, it then becomes more of a he said, she said scenario. So you always want to put the agreed upon terms in writing. You want to use simple and clear, plain language. You want to include payment terms. You want to date the contract. If you have insurance policies, you want to include that in there as well. And you want to identify the parties correctly. And you want to have a timeline. Is there a start date? Is there a completion date? Is there a deposit? And then after the contract is signed and say there's something, a last minute change that you want to enter into that both parties agree upon, you want to make sure the parties initial that change and date it, or you can include another sheet to the back of the contract that has that change. And you want to make sure you sign and date that. One thing you can do is have the parties sign the contract in the presence of each other. And you want to make sure that people that are signing the contract have the signing authority. So they will bind the company, corporation, whoever it is. The corporation then is bound to do their obligations as outlined in the contract. So you have to make sure that the party signing has signing authority. I also want to talk a bit about a confidentiality clause. So your business owner, you might have trade secrets or business information that you don't want other people to know about. You can include this in your contract. A lot of times people see these in their employment contracts. So that's something to consider as well. Next slide, please.
Okay, before I jump into the example, I'm just going to talk about briefly one thing you can do. If you're entering into a contract, it's always a good idea to retain legal counsel to have them review it. And if it's a contract that you're going to be using again and again and again, I would really emphasize we're a full service firm. We don't do corporate law. We only see when contracts go bad. So I can tell you from experience, it's often worthwhile to hire someone to formulate your contract, your standard contract, so you have a template you're using. So if you're in a business and you're constantly using the same document, if you pay a lawyer to do that upfront legal work and you know that you have a good solid agreement, you can take that and modify it for other clients, for example. So sometimes it's worth paying that, upfront fee to make sure that you're protecting yourself and that you've done everything properly. And one thing that we can do at a law firm that isn't accessible to the general public, we can actually do a corporate profile report. So when you're not sure whether this party you're talking to has the authority to bind a company, one way to check that is that we run a corporate profile report. And it's something we do in litigation. We run them before we sue parties when contracts have gone bad. But before you enter a contract with somebody, it's a very cost-effective way to ensure that the person you're contracting with is who they say they are, has the authority to bind the corporation, and there's a comfort level that you have from doing that due diligence. It's a fixed fee, it's not very expensive to run these corporate profile reports, and that's something you could even get done even without retaining a lawyer to do the general corporate work. You can request that we run certain profile reports. So if you're ever in a situation where the other party doesn't really know the corporate name, the corporate entity, whether it's limited, incorporated, these things matter. If you contract with the wrong parties, it just makes things more complicated when you go to bring proceedings. When you commence that claim, you're then suing multiple entities, people personally. You might do that anyways, but it's always better to have an airtight agreement up front so that when you go to litigate it, you know exactly who's involved and which party you're bringing the claim against. But I'll turn now to the example that we have. So this is just a very basic example. I could make it much more complicated, but we just wanted to give you an idea of here's something that could happen where you might need to have a contract dispute that arises and take steps to protect yourself. So the example is that you own a company, you install windows and doors, and that you order 100 windows from a new supplier that you've never used before, and you pay them an upfront deposit in order for them to then deliver the windows to you. So say you pay $100,000 deposit for $500,000 worth of windows, and the windows are never delivered to you. You have projects that you're going to install these on because you're a window installer. And so what are your options here? They're really, at its most basic level, you can sue the window supplier for the return of the deposit if these windows are never delivered in accordance with an agreement that you had. Ideally, that agreement is in writing. And so how would we go about doing that? We would send a demand letter on your behalf, or you can also send one yourself to try and demand payment, but it's often more effective when it comes from legal counsel. And then your other option would be to commence a proceeding. The third option, which I didn't list, which is to just do nothing, walk away from the deposit and never do business with that party again. That is also an option, but it's not exercising your legal right in any way. And I wouldn't often recommend that option, but sometimes for business reasons, you make that decision. But there are factors involved that I haven't listed, such, for example, if you could have a breach, not just a breach of contract claim if you commence a proceeding, but you could have a delay claim because was it reasonably foreseeable in those circumstances that that window supplier would realize that you would have a delay on your other projects, and you might have damages that you can prove and you can bring as part of your breach of contract claim. Another scenario is if the windows are in fact delivered, but 20 of the windows that you ordered of that 100 windows went missing. They were never delivered. So again, what are your options? You can send a demand letter, you can commence a proceeding. And when I say proceeding, I mean a legal proceeding that you're commencing. And we'll get into that on the next slide, the different types of proceedings. But in that case, you might be claiming against the supplier, but you could also, maybe there was a delivery company. Maybe you need to sue and provide demands to the delivery company. Maybe they have insurance for the windows that went missing. So you might not be clear as the company owner, this is the first time that this has happened and windows have gone missing. You might not be sure who you need to be contacting, who you may need to be demanding payment from, asking for copies of insurance from. So that's when you would, in an ideal world, pick up the phone and contact legal counsel so that we can assist you in how you would go about navigating the contract dispute. Next slide, please. Okay. So this is more detailed. I'm going through what your options are when a conflict arises. So the first option that most parties will explore is settlement. Now you can do this yourself, and often that's something that happens before parties come to us. They try and resolve a dispute. So if you have a situation like the windows where something wasn't delivered, usually the company owner will go and try and settle it with the company that was supplying it themselves. They will say, these were supposed to arrive, they never came, and they'll put these discussions ideally in writing. Often it'll just be a phone call to figure out what happened, and that's okay. But then you want to document that. You want to send a follow-up email saying, further to our discussion, these windows are missing. You said that you would do X, Y, Z. You can also retain legal counsel if you don't want the other party to know that you've retained legal counsel yet, because sometimes people get very, back against the wall. They don't want to talk. They don't want to discuss things if they think legal counsel is involved. You can do it with a lawyer in the background. They're guiding you and sometimes ghost writing for you. So that would be if I draft a letter and you send it with your own name, or if I provide the text of what an email should say and you provide that to the other side. So that can be a helpful way to reach settlement by making sure you're doing everything possible and in accordance with your legal obligations, making sure you're not demanding anything that you're not entitled to under the law, but also protecting yourself. So if it does go to litigation because you can't settle it, then you have legal counsel involved and things have been papered properly. It just assists you if it goes before a judge to make sure that everything is laid out properly. And then the other option for settlement is you can just have a lawyer. If it's not going well, you can ask your lawyer to send a demand letter. A demand letter is best used when there's threat of legal action. It doesn't help if you don't have a claim of action to send demand letters to people. It won't deliver results. You really need to have the ability to seek relief in the courts and obtain judgment. And so that's why you would get legal counsel involved, to make sure that you have a valid basis and then send that letter on your behalf. And if things don't settle or don't go well, and settlement's always the first objective. As litigators, we love going to court, but we don't want it to go that way. We want to help you and we want to facilitate settlement because it's the most cost-effective, efficient way if it's possible, and it serves the client's interests always fully to the best possible results if we're able to get that settlement early before parties incur significant legal fees. But there are other options you have. So if the amount in issue isn't a large amount, if it's $35,000 or less, you are in small claims court territory. So that means that you don't need legal counsel to represent you if it goes to court. Now, again, you can hire us to be on a limited scope retainer, for example, where we would assist you in, here's what you need to file your statement of claim, you go file it. Here are the documents we think you should rely on, but you as the person involved with the evidence, you can actually present that yourself at small claims court. The judges, the deputy judges that are there, they are very used to people representing themselves. Most of the parties don't often have counsel, and if they do, it's often a paralegal or junior counsel that would represent parties at small claims court. What's great about small claims court, you also don't need an order from the court. So if you're proceeding to superior court, you actually need an order as a corporation to represent yourself. It's a much more complicated step that I'll talk about on the next slide, but for small claims court, you don't need that. So the corporation, without any relief, can appear and represent you can represent the corporation in front of the deputy judge in those proceedings. Now, we've outlined some of the steps that are involved. The first step in seeking relief is drafting a statement of claim. So in small claims court, that plaintiff's claim is the first document that you do, and it's going to outline what you're seeking. What's the legal basis for your relief? And you attach all of the documents that you're going to be relying on. So it's a front-loaded process in small claims court where you provide essentially your key documents with your claim and you serve it on the other side once it's been filed with the court. And then in exchange, the defense from the party that you're suing, they will say what their version of events is, file their own documents in response. And then often where matters are resolved is at settlement conferences in front of the deputy judges at small claims court. They are used to having these meetings. They facilitate informal, confidential discussions between the parties. And it's really important that these happen because It's often, like I said, where parties will decide to settle. They don't want to take that full day off of work to go and argue in front of the court. You have to call witnesses. There may be, providing subpoenas, for your witnesses to appear that day. And as a self-represented litigant, for example, you may not want to do that. You may decide, I'd rather just settle this amount. It's less than the full amount of what I'm entitled to, but I'm willing to accept this amount to just walk away from this situation. So small claims court is great for facilitating parties to represent themselves, reach a resolution, and if there's no settlement, then it proceeds to trial. You can, like I said, represent yourself at trial, but oftentimes we might get calls from clients who are uncomfortable and don't want to do the trial themselves. That's fine. That's something, if you've prepared things, if you've had a limited scope retainer and you decide I want counsel or I want to retain somebody like a paralegal, then at that point, you can choose to do that. Just because you haven't had counsel before doesn't mean that you can't retain counsel for that final trial. Next slide, please. Okay, so now I'm going to talk about superior court claims. So this is where the money in issue is over $35,000 or more. Superior court claims are often, I would say usually around $100,000 is sort of where you want to be, just because of the amount of legal costs that are involved. There's also simplified procedure, which we didn't put on this slide, but that's $200,000 and under. So there's sort of different procedures. If you're in simplified procedure, it's a faster, quicker court process. If you're over $200,000, then you're in the regular superior court process. Court actions can take a long time to be resolved. You have to be mindful of that. It is not a quick procedure. So just because you've commenced a claim by suing another party, you would do that by drafting your statement of claim, having it issued with the court, filing it with the court is what happens, and then it's issued, and then you would be serving it on the defendants to the matter and providing your proof that you served it with the court. So everything can be filed properly, and then you would then receive a defense. So that's the pleading stage that happens at court. And as a corporation, like I said previously, you would actually need to bring a motion before a judge at court to obtain an order to represent the corporation. So there's a specific rule in the rules of civil proceedings, that the rules of civil procedure, that says that you must obtain a court order in order to represent yourself without a lawyer as a corporation. If you were an individual, if you were just named yourself, John Smith, you don't need that court order. You can represent yourself. The court is used to having self-represented litigants, even superior court claims where things are often complex and sophisticated. Judges will assist you. And if you have a court order that you've obtained, so if you want to represent yourself, you could come to a lawyer, for example, and say, I need help with drafting the motion materials that are required to obtain a court order to represent the corporation. That's something we could help with a limited scope retainer. And then we could guide you, if you need help later on, with different steps in the proceedings. Because once you're in superior court, you may be faced with things like a motion to strike or a motion for particulars, or you may, a summary judgment motion, all kinds of motion. And you may be in a situation, if you're representing the corporation yourself, where you don't know where these things are and you need some guidance. So there are resources available. The Law Society, there's pro bono clinics that are run through the Law Society. There's a helpline, a Law Pro helpline as well, but they are limited in what types of services they provide. And most of the legal help you would need to successfully commence or defend a claim in superior court, you really need to retain a lawyer. And if your budget only allows a limited scope, then that's something you can negotiate. There's also alternative dispute resolution mechanisms. So that was a very, very brief overview of what litigation is like. But essentially the parties exchange their written pleadings of what they think the dispute is about, and then you go before the judge Once the parties have had an opportunity to question on documents, to question each other on what the cause of action is, then you go before the judge for determination. A judge's decision is final and binding unless you have grounds to appeal, which is all guided by the rules of civil procedure. But the other option you have in contract disputes is to mediate or arbitrate. So these are considered alternative dispute resolution mechanisms. But I would caution, when you're using arbitration, it's much more similar to court, and people don't necessarily realize that. So mediation is an informal process. You hire a mediator, they help you negotiate. They're that neutral third party, and they really are there to help you settle. The mediator does not care whether you have a great cause of action. At the end of the day, it's their job to try and help the two parties come to terms. So mediation can be a great result, can give you a great result, particularly where you have an existing business relationship with somebody. They're a constant supplier. So if that window supplier wasn't a new supplier, but you have been supplying you windows for 50 years and then one of the shipments went missing, I wouldn't recommend necessarily that you go commence a proceeding or you use arbitration where there are delicate business relationships at play. You might want to retain counsel who can help you select a mediator, as both parties have to agree on the mediator. And we can tell you, who are the good mediators that are out there, who's cost effective. And then you would agree to mediate with the other party. Both sides have to go to it voluntarily. And like I said, they facilitate a settlement. So it's a process that's about reconciliation. Nobody really leaves happy. I don't want you to have that fuzzy, warm, sort of glowing feeling about it. Everyone's kind of a bit, wish they could have gotten more at the end of the day. But usually in the long run, parties are very happy when they mediate. It's not as confrontational. The mediator really just tries to facilitate settlement, to get a dollar figure that's going to resolve the dispute without giving you an opinion on your claim one way or the other. They may give you small tidbits because they're usually legal practitioners, but it's more about having that final resolution. Whereas if you go to arbitration, and if you put an arbitration clause in your contract, and you may have arbitration clauses right now in your contracts, in your corporate contracts with parties, with suppliers, and I would urge you to go through and look at them and look at which contracts you have arbitration clauses, and think critically before you sign another agreement with an arbitration clause on whether you actually want that clause in there. Because if the arbitration clause is in there, it's similar to court proceedings, but things are private. It's not a public decision that goes out into the world through publicly accessible databases. Arbitration decisions are private, and that is why a lot of companies like to use them. They don't want judgments out there with judges saying bad things about their business dealings. They want that all in private. But the arbitrator functions like a judge. So they aren't going to try and help you settle. They are going to decide the dispute, and it's going to be binding. They're going to decide based on all the facts and evidence that you present. There are rules and timelines, and if the arbitrator adopts certain procedural rules, for example, there's international arbitration rules, and if they adopt those rules, it's very, very similar to being in court. The requirements that you need to meet are very hard to navigate if you were self-represented. You really need a lawyer in those situations because it's a complex proceeding. Parties to the arbitration agreement, if you signed one, then you are generally bound by that. There are a few exceptions, but most of the time you're going to be forced to arbitrate. So that's why I say you should think carefully. And the arbitrator is chosen by both parties, but you still have to choose someone to decide the outcome. Next slide, please, Stephanie. Okay, so this is purely just about before you include those arbitration clauses in your contracts, here are some things to think about. So there are out-of-pocket expenses that are associated with arbitration that you won't necessarily have if you proceed by superior court, by commencing a proceeding. So for example, you and the other party have to split the arbitrator's fees. This is on top of your legal fees. So you're paying for a lawyer, you're also paying for your arbitrator. So those fees can add up very quickly and they can be significant. So for example, if you sign a lease agreement with your landlord and you're a tenant and you have arbitration in there, make sure that you are aware of the fact that if there's a dispute and you have to arbitrate, you're going to be paying these fees upfront. So you want to have reserves for that, because the arbitration process, once it starts, you can't stop it because you don't have funds. You could be prejudiced in your interests if you can't fairly represent yourself or pay the arbitrator's fees. In a court process, you don't pay out-of-pocket expenses for the judge. There are filing fees associated with filing certain documents. There are fees for legal counsel, but you don't pay the time for the judge to sit there hourly like you do with arbitration. So yes, it's a public proceeding and there's a final decision that's in the public record, but there's less upfront costs. So it's really about what's important to you as a business. Do you want that private confidential decision, or are you willing to pay for it, or do you want your proceeding to be in the court? I mentioned this briefly, but the procedural rules are very restrictive. There's time limits that you have for the delivery of certain items. You might have to do written submissions, legal submissions on what your cause of action is and why. And so you need to have a lawyer usually to assist you with all these things, unless you're a very sophisticated party that's done a number of these before and are willing to try it on your own, which I wouldn't really recommend, but you still could. And there's the issue of appeals. You can't appeal an arbitration decision the way you can a court proceeding. So there's certain items that you can appeal in a court decision. If there's an error of law, for example, you can appeal that to court. So not a finding of fact that the judge makes, but if they review the wrong legal principles, or they review a legal principle and decide something that's inconsistent with previous case law, you can appeal that to the Court of Appeal. In an arbitration, you don't have the same ability to appeal. So you really are stuck with the arbitrator's decision. And I just wanted to reiterate, because there's lots of case law in Canada about arbitration clauses, and it was recently heard just last month by the Supreme Court of Canada again. Now, this was a complex dispute involving a hydro dam and subcontractors, but again, the Supreme Court, time and time again, they're referring to something called the competence principle, which basically just means that the arbitrator has their own ability to look at an agreement and decide whether they can hear a matter, and that the courts don't interfere with that. So if you have an arbitration clause in your contract, the arbitrator is allowed to determine whether or not they have jurisdiction over that, whether they can decide the matter. And the courts, the Supreme Court of Canada, has said time and again that they will give precedence. So that means they will say an arbitration clause will override any other claim you may have in Superior Court, except for very limited exceptions. So if you're using arbitration clauses in your contracts because you think it might save you money, I caution you just to think again and reflect on what's important to you. And before you sign off on an arbitration clause, you might want to ask whether it's really the best thing for you as a contracting party. Next slide, please.
So this is our last slide. It's mostly an overview of everything we've talked about today, just a little summary before we go. So like we've said throughout this whole thing, you want to make sure you reduce the terms that you've discussed with the other parties. You want to reduce it to writing. Again, this helps to avoid potential litigation and avoids a messy he said, she said scenario. You want to ensure the correct parties are named. Again, as Melissa mentioned earlier, you can contact us and you can get us to run a corporate profile report that can assist in making sure you're using the correct legal name. You want to ensure that your contract sets out all essential terms. So the time for completion, is there a start date, your payment terms, is there going to be weekly, bi-weekly deposit, is there insurance, what needs to be completed, who needs to complete it, and if there's a delay, who's going to be responsible for that delay. You want to ensure that parties sign the contract, and you want to ensure that any changes are made in writing. or as an addendum to the contract, and any of these changes, they are date and initial decided. And next slide. And we're done.
Stephanie, are there any questions for us in the chat?
I'm just going to open it up. We don't have any questions, but if anybody wants to enter in a question, or definitely unmute themselves and ask a question, by all means, you're more than welcome to. Thank you very much for your presentation today. And we are recording, so I will have this posted up on our site in the coming days. I know it's sometimes a bit of information to write everything down, so the video will be available on our site this week sometime. So does anybody want to unmute and have any questions? Garvey, yes, go ahead.
Hi, thank you. It was a great session. Thank you, everyone, for organizing this. I have a quick question. I have a consulting company. It's a corporation. I have a contract with the company, and there is change in management, not the entity, but just the management. So who has signed the contract with me? So what happens in this case? Because my consulting runs for 3 years, and it's been a year and a half. Should I be changing? Getting the contract signed off by the new management? How does it go?
So if it's the same corporate entity and you have an existing business relationship and you're dealing with the same corporation, you don't necessarily need to get them to re-sign the contract. If this is an ongoing, it sounds like it's an ongoing consulting relationship. So I would be more concerned if there was, say, something like a change of control in the business and the ownership of the business, then you might want to have a new contract entered into. But you're going to be able to establish if you're rendering them invoices, they're paying you invoices under the new management, you would be able to establish, if it was to go to a court proceeding, that this is a continuing business relationship and that the manager changing doesn't impact that contract. You've contracted with that corporation. So that's really, at the end of the day, who you would sue, the corporation itself, if things were to go wrong.
Okay, that's great. So even if it is a partnership and one partner has bought out the other partner, so still the entity remains the same, right? On certain things.
As long as you know that the legal entity has remained the same.
Okay.
Yes.
Great. Thank you very much for that.
Thank you, Garvey. Does anybody else want to unmute themselves? I see Sherry. Do you want to ask a question, Sherry?
Hi, yeah, thank you both for the presentation. I just had a question about an aspect in regards to employment law. So I was wondering how to phrase like language in the contract for a non-compete clause to be more legally binding. I know because like for our corporation, a lot of employees are fully remote, so it's also hard to add like a distance, for example, for non-compete. So just any advice on that would really help.
So we are not employment lawyers. We have employment lawyers here. There's a lot of case law on non-competes, and I understand the difficulty that you're hinting at here with remote work. That would make, so non-compete clauses generally are only enforceable in certain circumstances, and if they have territory that's reasonable,
Right.
For example, and a term such as, 1 year or 2 years, you can't have a 6-year non-compete. But that's
Right.
all guided by case law, and it changes, honestly, every other month. So our labor and employment lawyers, we have Jonathan Morelli, who's here. He's fabulous. He reads and is up to date on all those case law. So if you had a question for him that's very specific, like if you have an existing employment contract and you just want to say, I need to update or non-compete, could you give me some guidance on what the courts are saying? That's something he could do on a limited scope retainer and give you a quick opinion. I would really recommend something like that, because anything I tell you right now is probably not going to be right. So.
Okay, got it. I appreciate that. Yeah, thanks for putting out Jonathan's name. Good to know.
And on that note, I think Jonathan will be doing an event in January with us, a webinar on a similar topic. So definitely stay tuned for marketing and the registration information for that. That will come back in January.
Great.
I'm not sure if there's any other questions. Good. All right. Well, I want to thank both of you for joining us today. Thank you for this presentation. As I mentioned, it is recorded. It will be posted on our site. And we definitely have a few more events left at MBOT for the remainder of the year. And then we have a great 2023 lineup, Kaiser Mason Ball as well, doing webinars every month with us on a different topic. Definitely look at our calendar, register online, and we look forward to seeing all of you at our future events. Thank you, everyone. Thank you again, Melissa and Jennifer. Have a great day.
Thank you.
Thank you.
Take care.